Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. We're going to be talking about divorce and family law to start off this segment. And my co-host, welcome in Jesse Barrientos. Jesse, how are you, sir?
Hey, very good, Dave. How about yourself?
Oh, doing well. Well, you know what? It's the time of the year, believe it or not, things are starting to bubble a little bit.
They are.
With divorce and family law. Things are changing. Real estate values are going up. People who have been together for the sake of not wanting to move their real estate, waiting until the value went up, is starting to move up. Summonses are flying out the courthouse door. In other words, divorces are up. Have you noticed this?
Yeah, I do believe that it is up a little bit. Probably has something to do with that. I don't know if it has anything to do with getting things done by the end of the year.
Yeah. Now, it's nothing to get excited about. Obviously, we don't encourage this kind of thing.
Right.
You and me both speak about working things out to the best you can and trying to find help. But sometimes a marriage is broken down to the point where it cannot be repaired, and in some cases should not be repaired if there's domestic abuse and violence and things of that nature. So we have this reality that couples don't last, 55%, I think, nationally in the country.
That's about right.
And we have a system set up throughout Illinois, the court system, that tries to do right by the parties and the family. And unfortunately, as one of my old associates used to tell me, the civic system is not set up to adequately solve the problem of divorce and family law, but it's the only system we have. So let's dive right into it. How does someone initiate a dissolution action through you?
Well, the first thing, obviously, that happens is they come in. We go through their particular situation because each situation is different. There are a lot of things that happen that are similar, the process and everything else, but depending upon the specifics, you may go in one direction or another. But it starts by drafting and filing what they call a petition for dissolution of marriage. And that gets filed with the court, a summons gets issued, and then served either by the county sheriff or by a special process server, or you can have somebody else appointed as a special process server. It depends on where you're at. I believe in Cook County, the statute says since there's more than, I think, 2 million people, that you have to have the sheriff try first. And in counties that have less than 2 million, you can have a licensed private detective agency without getting a specific order that lists a process server. If you want an individual who's not a licensed private eye, then you'd have to get your order. And then
Now, this is a sensitive time, this service of process. That's
Right.
when the respondent, the person being sued, first becomes aware of the case. Now, if you got a couple that's still living together and the process server comes to the door to serve one of the parties, you could have an incident right there based on this filing.
That's true, and it's also problematic when you have a situation where the person is living at they're living in the same house or same apartment, is that, and I've seen this on occasion, where the process server will come and serve the petitioner by what they call substitute service. You can serve by various different ways. One is personal service, where they give you the summons and the petition for dissolution. Another is substitute, where they can serve anybody that is 13 years of age or older. And then they also have to send a hard copy via mail to you as well. Or you could serve by publication. There are other ramifications with respect to that. But when you have a substitute service situation, and again, if it's the petitioner who's been served, there's been some instances where the petitioner doesn't say anything and doesn't let the respondent, the other spouse, know that they've been served. And so then time goes on, and then they get a default judgment, and that gets a little hairy. I really try to stay away. Really try to either make sure that the respondent gets served himself, or that he gets served at work or something. I hate to do that at work, but this way it gets rid of all the problems.
To give a real life example here, we have a case pending right now, names to be silent on, but the respondent, the husband, was served at his place of employment. Now the couple is still living together. Well, the husband got served, and he hasn't said a word to the spouse. They're living together now. that he was served. His demeanor hasn't changed. He's the same guy in the house. He's really playing coy. But as you know, and you're going to advise everybody right now, that person has 30 days from the date in which he or she is served to file an appearance with the clerk of the court, or they can be held in default, right? Is that the next step?
That is an appearance and an answer to the petition for dissolution, or
Well, definitely an
or
appearance.
respond. Definitely an appearance, and there's going to generally be a fee. If it's a situation where you can pass the threshold and do what they call a pauper's petition, I think it's a 298 petition where they waive the fee. It depends on which county you're at.
Yeah, don't plan on getting the
Some
fees waived.
some counties are better. Well, it just depends on your financial situation. If you own a house and there's equity, probably not. But at least that's available, and that's the first thing. The first thing you need to do is to really talk to somebody who does domestic relation. You need a domestic relations attorney, somebody who has done that for a long time and who is aware of the ramifications and the laws. And it's really nice to have somebody who is aware and familiar with the judges in the specific
Okay,
county.
so don't
that
go to
you're
a guy who did the real estate closing on the house, or the guy who handled your son's traffic ticket or criminal case. You want someone who's experienced in divorce and family law.
Right. If and there are people who do general practice and who do a large volume of domestic relation too. I mean, that's okay. But again, you want to make sure that they're doing more than a couple cases a year, that they're familiar with that. And again, the clock starts ticking. I get so many people that give me a holler and give me a call, want to set up an appointment. When were you served? Almost 30 days ago. And it's really difficult because, ignoring it is not going to make it go away. You have to deal with it. You have to face it head on. And again, as you said, you got to file your appearance, and then you have to respond to it, whether or not that's an answer to the specific allegations. And it's got to be tit for tat. Paragraph 1, admit or deny, or kind of plead lack of knowledge and say, hey, listen, you know what, I can't admit it or deny it, I don't have enough information, so I can't do either. Because it's very important, the rules say that if you don't do that for each and every one, all right, anything that's not specifically denied is admitted, any allegation. Now, you could also file what they call a motion to dismiss if the petition for dissolution of marriage doesn't have the proper allegations as required by statute.
Aren't you really prolonging the inevitable?
You are.
Don't you want to get involved in the case and,
You do.
and get it to a point where we can start resolving some of these issues? And I want to talk about that too. This is a court of equity, and the court is going to try and do equity, correct?
That's right. They're going to try to divide the pie, and they're going to look at all of the assets, and they're going to look at the liabilities, and that's just with respect to those kind of things, not even talking about custody. And then they're going to make a decision.
Okay.
After trial, of course. I mean, we're just, that's just a really abbreviated version of what's going to happen.
All right, let's talk about the property. Let's take a couple that owns a house together. They have a couple cars. They each have a retirement account, some savings accounts, a checking account. What's going to happen vis-a-vis the property?
Well, it really depends. Generally, any property that's acquired during the course of the marriage is marital property. And any debt that's acquired during the course of the marriage is marital debt. There are some exceptions. One exception would be, for example, an inheritance. Let's say, for example, that the husband inherited $1 million from Uncle Charlie, and that went into a separate account, didn't put his wife's name on it, just left it there. That typically is going to be his non-marital property. However, the court takes into consideration the value of your non-marital estate. You need to think of it like an estate. Marital estate, okay, everything you got during the course of the marriage. And then non-marital, okay, everything I had before the marriage, or like the inheritance or gift or something like that. And the court is going to take that in consideration. And so let's say our marital estate in this situation is worth, a couple $100,000. Maybe that's the house, a little bit of equity, bank account, retirement, whatever. And, this guy's got $1 million. Well, probably the other spouse is going to get the lion's share of the marital estate because, again, as you say, they're trying to equal things out.
There's some new activity going on at the congressional level. I don't know if you're aware of it yet, but supposedly they're trying to work something where property will be de facto 50-50 to try and get that division of property equalized so it's out of the framework, it's out of the equation with regard to a dissolution action. not talking about maintenance or child support, but just the actual division of property, instead of fighting over a percentage there, they want to have a de facto 50-50, and that's what the legislature's working on. This is what I'm hearing.
Well, I really haven't heard that, but I have to tell you that I disagree because it's not, nothing is 50-50. Every relationship, you have a relationship with your spouse, okay, it's not 50-50. One day it's 60-40, one day it's 70-30, one day it's 90-10, and it goes back and forth because that's how life is, that's how a relationship is.
Maybe in terms of who's doing what, but if you're acquiring something as a partnership, that partnership could be deemed 50-50, despite the fact that one partner is doing something and another partner is doing another. I mean, you know, from businesses, partnerships, no two people are doing equal jobs in the partnership, but they have a 50% stake, don't
Well,
they?
that's different, and a partnership is like a marriage, but this is under the Illinois Marriage and Dissolution of Marriage Act, and I don't think that it's fair because, you know, what happens if you have a spouse who really stood home and raised the kids and is older and maybe is not going to be able to go back into the workforce? Sure, you have maintenance and things to take care of that, but okay, you know, maybe that person, to make it equitable, needs a larger share of the property. Again, that's the way it's always
Well,
been.
we're going to have to disagree on this one
Yeah.
because I don't think that spouse is entitled to more than 50% or less than 50%. I think she's entitled to, or he is entitled to 50%. And then we work on the other items.
Right.
Maintenance is another factor, child support, allocation of debt, but just property.
I
This is what we acquire during the marriage.
Right.
It's 50-50.
I
like
think-
that deal.
I think it depends on the specific circumstances of the case. In a lot of cases, it may be 50-50. But, you know, Dave, if you were making $250,000 a year and I'm staying home with the kids, the wife is, and taking care of the kids and not doing anything, yeah, of course, I could see where you would see where it would be fair to you to get 50% and the other person 50. Nah, not so much. That's not equitable. And again, we're dealing with the Chancery Court, which is the equitable division of the marital estate.
Okay, well, we'll see how that goes. We'll see
Yep,
what happens.
we will.
Let's talk about custody. It's the main topic on most people's minds when they have children. How is custody decided, and what is involved?
It's a lot of heartache, a lot of emotional distress, really, for the parties, for the attorneys, for the judge, but especially for the children. Because I don't care how young your children are, they know what's going on. In fact, all of the counties really have a requirement that people have to take a parenting class, and essentially, it's really how to deal with the children and the effect that a divorce has on them. Unfortunately, a lot of times, parties use the children as a pawn to hurt the other person, or a lot of times what they do is they alienate the children from the other person, which is bad-mouthing the other spouse and saying that they don't love them, that they left, just all those kind of things. And, you know, it's unfortunate that happens, and there's only a limit to the things that you can do. So custody is one of those really tough kind of inexpensive areas because it's not just time consuming, but a lot of times the court will appoint what they call a GAL, which is a guardian ad litem for the child, which is not really the child's attorney per se, but is an attorney who's appointed to do an investigation and report back to the court on what that person believes is in the best interest of the children. They have a child rep and an attorney for the child, and those encompass different things. Depending upon which county you're in, you know, it will vary, but for the most part, I believe they would most likely appoint a guardian ad litem. And that person, again, would do the investigation, do a written report if it is ordered by the court, sometimes, depending upon the situation, to save money too, based upon the circumstances and finances of the parties. The court will just require or ask the guardian ad litem to give an oral report. And that's probably more true when you have a pro se, and pro se is people representing themselves.
Yes, because this guardian has to be paid.
A guardian has to be paid, exactly.
And it's expensive.
It is. And then sometimes the court or either party can petition the court, or the court can do it on its own motion, appoint what they call a 604B custody evaluator, which is a psychologist. And that can probably set you back anywhere from probably $8,000 to $10,000 for that report. It's probably going to take several months to get that completed, and the psychologist is going to interview each and every person involved is going to interview the kids and going to give them psychological tests, and is going to do the same thing with the parents. And maybe if there is a paramour or somebody living with the spouse now that they've separated, or grandparents or whatever, they're going to investigate and look at records and look at allegations and look at all kinds of things. And then they are going to make a determination on what they believe in their experience and their profession is the best interest of the children. And again, sometimes you can, the court can appoint a guardian ad litem, and there could be a 604B involved. I was involved in a case where there were multiple issues there, and again, that gets to be very, very expensive.
Yeah. Let's talk about the misconception out there, particularly with men who feel that if they don't have physical custody, that they won't have a say in the child's life. And sometimes mediation clears this up, but
Right.
can you explain to the
I can.
to the viewers out there how this works?
I'm actually a mediator in DuPage in a GAL as well. And so essentially there's a couple different types of custody when you look at it. There's essentially, when you boil it down to it, there's sole custody and there's joint custody. There are variations on joint custody. Sole custody means that the non-residential parent, the parent who does not have physical possession of the kids most of the time, does not have a say-so in the upbringing of the children in just 3 areas, and that relates to education, medical, right, and religion.
Okay.
Just those 3 areas.
Just those 3.
Just those 3 areas. Now, joint custody is kind of the opposite. It means that the non-custodial parent has a say-so in those things. However, I find as the child gets older, those issues are already taken care of. All right, are you Catholic, Christian, whatever? Okay, that's
Right.
already taken care of. That's not a problem. Or a lot of times they're not doing anything. They're not.
And that relates to education too, whether it's private or public school.
Exactly right, and they're already going to, so that's kind of settled. And then when you get into medical, and I always tell people, I say, well, you know, here's the thing with medical, it really goes to elective types of things like orthodontia or things that aren't medically necessary. Because if there's an accident that happens, obviously, yeah, of course, you know, you don't need, you know, you need to get the child to the hospital or whatever, and let the other parent know immediately. So generally those things really don't, you know, it doesn't mean that you're not going to see your kids. It doesn't mean that, you know, when they're with you, you have a say-so. You know, you're able to call the day-to-day decisions when the children are in your possession for parenting time.
Right. I think in many cases, sole custody is nothing more than a power play, where one parent is trying to run roughshod over the other just to dominate, take control, and say, I got sole custody, you don't have a say. But in reality, what you just said is true. There is almost a say, or at least an understanding of this is how things are going to be.
Right. It's already been taken care of.
I think it's more when you have an unhealthy parent, whether it be some sort of addiction, neglect, or the inability, mental illness. I think that's where the fight for custody, sole custody, comes into play a whole lot more.
I think it even goes into other things, because for joint custody, what needs to happen is both parents need to be mature and responsible, and they need to be able to cooperate as it relates to the decisions for their children. If they can't cooperate and they can't talk, then they're not really a candidate for joint custody. And now we're talking about, okay, who has physical custody? Because, you know, there's a lot of times when, hey, you know, people just don't see eye to eye, and people are just arguing for the sake of arguing. And, you know, when there's not that cooperation, when there's that lack of cooperation, joint custody is not appropriate. But here's something else I find too. Even when people, you know, when there is joint custody, the other parent, the non-custodial parent, generally doesn't exercise those kind of things.
Right.
And that's unfortunately the way it goes, because as I said earlier, as we talked about, those 3 areas are already taken care of.
Let's talk about what every non-physical custodian parent cares about. Child support. How much? How often? Why?
Well, as you know, and we've talked about on other shows, I'm a firm believer that they're your kids. You have to support them. I've even had people that have come to me and there's no order in place or anything else, and they've separated. Maybe there's not even a case filed. Oh, do I have to pay child support and everything? I said, well, you know, legally there's no order, but you know what? Those are your children, and you made them, and you need to take care of them. Okay, it's not fair to put all that on the other spouse. Okay, I don't care what you think about her or him. You don't like them. Their feet smell. They're just horrible people. Doesn't matter. You need to support their kids. And unfortunately, this is where the problem comes in. There's no accounting for child support.
Right.
So
The
people
money
get-
doesn't get paid to the child. It
Well,
gets paid to the custodial
to the
parent.
custodial parent, and they could do with that money whatever, because people have a problem. Oh, listen, you know, she's got a new Prada purse or whatever, and that's the child support money. There's no accounting for it. Child support is intended for things: a roof over the child's head, groceries, utilities, all of those things.
Not only that, she could be buying Happy Meals for the kid and taking the additional funds and going out with her girlfriends
She could
on
exactly
the
right.
nightlife.
Right.
And
That's
there's
true
nothing
too.
you can do about it.
Nothing you could do about it. That's the way that it goes. And typically, what happens is, and both parties are required to contribute to the care and upbringing of their child. And so it depends upon, if you have one child, the statutory guideline is 20% of your net. 2 children, 28, 3, 32, and it's progressive. But
And
net
you can't
income,
fool with that. You can't downsize your position. You can't quit your job. You can't take a $100,000 career job and start working as a delivery person for furniture.
Well, sure you can.
Well, you're going to get caught.
You're going to get slapped, because if the court, let's just take a situation where somebody has one child, it's 20%, to make it easy, and let's just suppose that, I guess that their net annual income is $100,000. So that's kind of easy. So what does that mean? Child support is a year.
$20,000.
$20,000. Okay. So, all right. Now, and it gets broken up. I mean, depending upon the employer, how their pay schedule is, it could be, because people get paid once a month.
It's about $400 a week.
Right, but
Roughly.
people get paid weekly, monthly, bi-weekly, bi-monthly. I can't imagine somebody getting paid yearly, but I suppose that could happen too. But so you have all those things, and so whatever the amount is, it can get broken up and paid depending upon the employer in any one of those kind of increments to be able to kind of take care of it. So all right, now, so this gentleman then decides that, hey, listen, you know what? I'm tired, because every time I see you, you have a new purse or a pair of shoes or something else, and the kid looks a little skinny there. It's not, I mean, that brings up some other issues too. But hey, you know what? The heck with this, Dave. I'm just going to quit, and I'm going to work at McDonald's. Okay. Well, if the court determines that you voluntarily separated yourself from employment, you weren't fired for
Right.
cause, then they can impute that former income to you, so that your child support obligation is going to be just as what it was when you were making that $100,000 a year net. So, and I have a lot of people sometimes that do that, and I tell them, I say, you know what, do whatever you want, but I'm telling you, this is what's going to happen.
Yeah.
You want to quit your job? That's up to you.
It doesn't make sense. Keep
doesn't
working
make
hard,
sense.
do right by your child.
Right.
And if the spouse is spending money on him or herself, there could be an upside. The person could wind up finding another mate, which would then terminate maintenance, which leads me to maintenance. How is maintenance, spousal support, one for the other? Not child support, but for the other spouse. How is that calculated and determined?
Well, it's going back to what we were talking about before, about 50% of your property, remember? Okay, so we look at the positions of the parties. So let's go back to something we talked about before. Let's use the same example. $100,000 for Mr. and Mrs. has stayed home with the kids and has raised the kids, and
But she is educated. She does have a college degree.
no, but let's say that she's a little bit older, and it's difficult sometimes to be able to do that. Now, there are different kinds of maintenance, okay? There is what they call rehabilitative maintenance, which essentially is for a period of time in order to re-educate or allow the non-working spouse time to get training to be able to re-enter the workforce.
2 to 3 years on that kind, correct?
It depends. I mean, that's probably generally what it is, but it depends on the length of the marriage as well. There's a lot of different factors. There could be reviewable maintenance, which generally, again, depend upon the length of the marriage and dependent upon the county and judge you get. Let's say 10-year marriage, could be 3 years, could be 4 years, could be 2 years.
Problem is you're going back into court to have that reviewed and to have another judge decide on it, or the same judge.
No,
I like maintenance and gross. Talk about that one if you would.
well, we will, but let's talk about one more thing first, and it will build up to that. The other one is permanent maintenance, and that's a situation. I've had a couple things from time to time here where the folks are older, one of the spouses that's going to be receiving the maintenance is disabled and can't work, and so it's going to be permanent maintenance. And they're going to equalize what the income is pretty much until that person passes away or gets married, or until the payor passes away, or until his situation changes, something like that. And then maintenance and gross. Maintenance and gross is a specific dollar amount that's paid over time, so in installments. So let's just say maintenance and gross of, $120,000, payable in 12 installments. So what's that, Dave?
10,000 each.
10,000 each. So every month, 10,000 bucks. That's good and that's bad. And again, you could use whatever figures you want. You can
prepay that though.
You could prepay that, but you could use whatever figures and make it less or more, or expand it instead of over 1 year, 2 years, whatever. I mean, it just the concept is the same. The problem with maintenance and gross, well, the benefit is that that's it. There's no coming back into court. There's a light at the end of the tunnel. After that last payment is made, you're done.
Is it subject to statutory events?
You know what? It is.
It is.
It is.
So it's not truly non-modifiable.
Well, no. However, here's the problem with that, though. Barring that, and we'll talk about those triggering events, barring that, the problem is going to be this, all right? If something happens to my job and I get fired, and then I'm actually truly working at McDonald's, not because I quit, but because I got fired and I'm stuck. That's the amount I got to pay. Too bad, so sad. So, it's a little bit of a gamble. Yeah. Statutory events for terminating maintenance in any of these situations, a lot of times, and it's got to be specific, it will tell you that you have to do, 36 payments or whatever it is of X amount, or it could be that the cohabiting on a continuing conjugal basis with someone else, unless that's written out of it. If that's in your agreement, it just depends on what you're in agreement to, because you can exclude that. Mm-hmm. Either a party dies, those type of things will terminate maintenance. Okay. We've got one going right now where it's cohabiting, and so it's just identifying the time when that cohabitation occurred.
Okay. There's also plenty of cases where someone specifically will not move in with someone that they have a relationship with, just to avoid that appearance.
Absolutely.
Okay, so there's things that people can do.
Right, but there's not. I mean, how are you going to prove that unless you hire a private detective and there's a lot of complications. We can say what these things are, but then proving them is another matter.
Right. Okay, so just to recap, in the minute we have left, we have the filing of the petition,
right,
service of the summons,
right,
and then we have the issues involved in the case: custody, support, visitation, division of property, right, allocation of debt, possibly a custody battle, possibly just a nice contested case that turns into a uncontested case with some good advice from counsel, correct?
Well, that's correct, and a lot of cases do end up settling. That's it in a nutshell, really.
Okay. So your recommendation would be what to do first? Make an appointment, speak with an attorney?
Exactly. Speak with a domestic relations attorney. And it's okay if they do other stuff, but as long as they're cognizant and they've been practicing in that area for a while, you want to make sure that you have somebody who knows what they're doing. And it doesn't hurt to have somebody who's familiar with the judges in the particular county that you're at.
And also do some research, right? Go online.
Absolutely.
Read a little bit about the statute, get familiar with the situation, so when you're talking to that attorney, you have some knowledge on that. Yep. All right, Jesse, thanks for joining me today.
You bet, Dave.
You've been watching Divorce and Family Law. This is Legal Action. We'll see you next time. Take care.